very pleased you're here.
Well, I appreciate it. And I appreciate the opportunity to come down and speak with everybody today. I will try to be brief, and as has been pointed out, this is an extremely large and complex topic, much more so than you might imagine. And there's simply no way to unpackage it all here this morning. So what I endeavored to do, kind of the last minute, was pare down as much as I could so that we were hitting the right themes along the way, that we were walking a path that was paved with truth, and that hopefully it would stimulate some discussion after the fact. I will openly admit that I wasn't entirely certain today was going to happen, so I made a couple last-minute arrangements way late last night, and we'll be going together through this for the first time this morning. So, as a matter of agenda, I thought it was important because my name has somewhat been affixed to this issue that I'd share a little bit about who I am. But I want to talk a little bit about why I investigated further, because part of this effort was fact-finding, but it was also an opportunity to demonstrate the power that citizens have if they actually engage in an issue and pursue the facts. I'm not going to spend a lot of time on why it's important to fight for transparency and accountability, because everybody in this room knows this by virtue of being associated with this group and coming here this morning. What I actually did and what I found, and then we may have some time to talk a little bit about what happened since. Real quickly, I think as has been shared, I'm a 15-year resident of Georgia. I'm a former U.S. Marine with an intelligence background. I served in both Desert Storm with the DIA, the Defense Intelligence Agency in El Salvador, and then Mogadishu. Former FBI Special Agent out of St. Louis. I was assigned to a public corruption squad there. I've been a business executive for 17 plus years, and I own two rather successful businesses here in Georgia. By rather successful, we're an international footprint. We've generated $140 million or so since we've incorporated and employed some 700 people. So the reason I share that is one of the prevailing counterattacks to my effort when this went out, at least the politicizing of it, was that I must be being paid by some shadow group. And that group ranged everything from, ill-defined shadow group to Democrats. And I thought, well, that's just absurd. I most certainly never received anything from anybody, and it would have been foolish for anybody to offer it. Well, let me talk a little bit about why I investigated, because I think it's important to understand what motivates behavior. In fact, motivation is one of the things that we fail to look for in people's behavior, and it's absolutely insightful. For me, I was shocked, and I think there's a lot of people that if they're not inside the legal system, and if they're not necessarily tracking what happens inside the legal system, they were shocked to learn that an individual with the stroke of their pen could absolutely, unilaterally, without check, just say, no, I'm not coming to court. And by virtue, neither is my criminal defendant. I actually didn't believe it. So the story went out with the AJC. Johnny Edwards had printed, I didn't know Johnny prior to this, in February, a story working with WSB. And I read this like a lot of people did. And it was the first time in my entire life that I reached out to a media organization. Because as you might imagine, I'm happy to keep them at arm's length. But I reached out to Johnny Edwards. I sent him an email and I said, listen, here's my background. Is this true? If it's true, what can I do to assist? I was that outraged. And I think the cases that were highlighted in there, which we're going to talk about the disposition of a few of those, really set me and a lot of people off. How could this possibly be true? I actually didn't believe it. I wanted to see the actual documents for myself. It was one of the first times as an adult where I said, you know what, I don't believe anybody about anything anymore. I stopped believing anything I saw in the media. I'd like to see this for myself, and I was very curious how to do that. So in that communication, I said, how do I plug into this effort, and what can I do, and where can I get more information? But they very gently kind of said, hey, thank you for reaching out to the AJC, and here's a pen, that sort of thing. But what they did in that process is they put me in contact with somebody else it was a producer in another media outlet. And when I talked to her, she said, well, listen, these are all publicly available records. You can go down to the courthouse and look at them yourself. And as a prior law enforcement officer, every document that I ever got was the product of a court order. I never thought about the idea that as a citizen I could just walk in and say, I want to see these documents, and they had to show them to me. And I'll talk about that here in a minute. So I wanted to see them for myself. And then, and I'm going to show a little bit here on the next slide, the speaker started making statements. And what I thought were interesting about these statements is here was an individual accused of an abuse who's explaining why it was an abuse, explaining that everything's okay and he's going to make everything right again. And I thought, well, you know who's not involved in this discussion are the people that were subject to the abuse. which, by the way, is every citizen of the state. These are cases the state versus, right? We're the state. So I'm looking at this and I'm thinking, well, you know what? I think the people of Georgia deserve to have a conversation about this issue that's not driven by the accused take on what they did, but how about the facts? Let's just go with the truth, as uncomfortable as it may be. And when I set out on this, by the way, I didn't have a preordained outcome in mind. I didn't think, okay, I'm going to be the guy that nails this fellow to the... No, I just was going to go look at the documents. And if the document said he didn't do anything wrong, I would have sat at a bar next to anybody else and had my pint and said, no, he didn't do anything wrong. But he did. So on June 25th, so now my curiosity is piqued as others, and the speaker goes to the well because he's subject to a lot of scrutiny by his colleagues. By this point, I think that it's been clear that there were legislators that have come out to call for his resignation, and he made a few statements that caught me as interesting, right? I think Michael will agree with me as an investigator. I don't know if there's other investigators in the room or trained investigators. This first statement really got me. It really caught me. And in fact, at this point, I wasn't fully engaged. He said, an examination of all the facts causes me to reject in the strongest possible way any accusation or insinuation that I've abused or misused my position. Imagine you're accused of something and you say, you know what, I'm going to go look at all the facts surrounding what you're accusing me of, and I'll get back to you to let you know whether or not I did anything wrong. So it seemed to me that if I were interrogating this individual, I would immediately clue in on this, because I'd say, you know what, that's interesting. You're distancing yourself from a behavior that you're saying probably didn't happen. Why would you do that? Why would you just not unequivocally say, I've done nothing wrong? No, I took the time, I examined, I have children. Dad, I thought about everything you said. I looked at the broken glass, I looked at the milk, I looked at my sister crying over in the corner, and I've concluded I've done nothing wrong. I've never had that conversation with my children. And the next part of that was when I come back, that perception becoming reality. So this is a very important statement if you're sitting across the table from somebody that you think's done something wrong. Because what they're saying is, and you heard it many times, hey, listen, you know what, I didn't do it, but if that's what they say, that's what they say. Well, no innocent man or woman ever takes that tack. You either did it or you didn't do it. You either know you're wrong, you're morally, ethically reconciled to your behavior, or you're not. Right? Not all the continuance is requested by me. Interesting. Okay, that caught my attention. Not one time. So when you get into absolutes, this is important. So not one time. I never want to say to anybody who's an investigator anything absolute. I never in all my legal career ever had anything questioned about my use of legislative authority. Well, okay, you just gave me my first mission. Let me go see if that's true. As a lawyer, I have zero control over the court calendar. Well, we all know that's not true now. So I'm listening to these statements, and I'm thinking, you know what? I have better things to do. I'm not a politician. I'm not particularly interested as much as the apparatus has tried for a decade to get me to become one. I'm not terribly interested in becoming one, but I have the resources, I have the training, I have the passion, and I'm slightly outraged now because I'm seeing this as something more than just the delay of cases and the delay of trials. I'm looking at it as we're sheep, and we're told what to think and how to feel. Now we're being told how to respond to something that maybe morally we take exception to. And we're just to take it and to walk away. And that's what I took away from this. And I thought, you know, no. I think I'll stir it up a little bit this time.
You have.
So you don't need to know why we have to question authority, but I like the statement. And as I'm going to jump forward in time a little bit because I want to play a video, and hopefully I'll do this well, that makes perfectly clear the point that I'm trying to make, and then we're going to dive into some detail. So bear with me with my audio-visual skills here, but it's a video of Speaker Ralston flanked by two ranking members of the House down in Savannah with the Savannah Chronicle talking about this matter. So he went on a media tour, which didn't go very well, frankly. But he went on a media tour, and in one of these he decided he was going to take a shot at me, which I have no problem with, right? Metaphorically or otherwise, bring it. But have your facts straight. And whatever you do, don't question mine, because they're all signed by you, not you, David Ralston. This may or may not work, and if this doesn't work, I will do it a different way. It will work.
You know, and you know, going back to the attacks, and this doesn't get reported, but you know, the former FBI agent has recently said that a lawyer that was in my law firm for about 6 years, no, actually 9 years, judge 6 years, now in the Court of Appeals, that presided over my cases, approved my legislative leave request, and dismissed cases for me. That is so blatantly untrue. I went into that judge's courtroom one time when she was a Superior Court judge, and that was to wave at her because I hadn't seen her on the bench, and she was kind of like a daughter, and so, you know, I don't know where this kind of stuff comes from, but that is an attack on her. That is that we just have to call it what it is. It's a lie, and I think, you know, Barry Fleming and I try cases, and you know, there's a principle of law that says that if you find somebody has lied one time, you can disregard their entire testimony.
How appropriate. If you find somebody has lied one time, you can discount. Well, the papers in your hand, by the way, are how it is that I came to conclude that his former law clerk, who got appointed to a judge, presided over his case, dismissed them, and in fact approved his legislative leave. Pick a fight with me all day long, just pick a good one. That was not a very good one. And hopefully this will come back to life. So what I hoped to capture there, because I have another video which we don't have time today, was how comfortable he was looking at the camera, flanked by two ranking members of our House, and saying that I had lied, that this judge, Amanda H. Mercier, who again, I'm not suggesting she did anything wrong, but how could I possibly suggest that she would ever dismiss any of those cases? Well, you've got the dismissals in your hands. How could I ever suggest that she approved his legislative leave? Well, you have his signed letters to her in your hand. How could I possibly suggest that she presided over those cases? Well, last I checked, if you're the judge that's approving the leave and you're the judge that's dismissing the case, there's a very good chance you preside over it as well. That's kind of how the system works. Incidentally, she became a Superior Court judge after 9 years as a lawyer in a small office up north. It's not an anomaly. The very next person that worked for him, Clint Bearden, also became a Superior Court judge. So he has a 100% track record of Superior Court. And this is why we can't do this, because there's so many tentacles that this goes down that you have to have some investigative discipline. Well, these are the documents that we're handing out. And the reason I want to share this is because, and you know this, the powerful lie to us. And not only do they do it, but they look you right in the eye and they say, you know what, it never happened.
Yep.
It never happened. And you're holding the paper in your hand, you say, sure, this is, well, it never happened. Well, it did happen. And here's a curious one I just want to point out. You have these documents. Document 1, and this is just me showing off a little bit, I'll be honest. Document 1 is from 2010, February, and it's a letter from David Ralston asking for legislative leave for a specific case. Amanda Mercier is an employee at that time of his, and she's actually the one that signed the request. Okay?
No.
So she signs the legislative leave request for this case in February 2010. Just 3 years later, she's receiving a request for the same case from David Ralston and approving it. So here you have somebody that once worked on this case, now approving the legislative leave for it. And the Speaker has the audacity to say that I was lying. I can't be the only one that has an issue with this or sees the conflict with this, right? That you say, well, this never happened. No, not only did she do these things, but she approved these for cases, and she dismissed cases that she once potentially worked on. Wouldn't you like to know that? If you were on the receiving end of whatever this individual did? Of course you would. So that's my fast forward in time that says, you know, every time I went through this and I thought, okay, I've done my part, I've gotten the data, I'm finished, I did my part, he comes up and he does something like this, and you go, okay, round 2, round 3. Well, let me talk about what I did and what I found. So number 1, very simple. I traveled a lot. it would have been far more convenient for me if the speaker were abusing his powers in my county of Forsyth. That's not really what was happening. So I spent a lot of time in Georgia courthouses, and the closest one was probably 50 miles away. So I must have driven 1,000 miles or more. At one point I was down on the coast in Florida on a vacation with my family, and I had this epiphany. I couldn't sleep. You know how it is when you get on the hunt and you know you have it. And I thought, oh shoot, there was a document in Gilmer, and I didn't copy it. And I'm down at the beach. And I told my wife, I said, you know I love you, right? Because I'm going to drive to Gilmer County from Orange Beach. And I got my car and I drove all the way back, caught some sleep, went up, got the documents, and then went back to Orange County. And I'll show you why here in a minute. So I went to these counties, and I'll tell you the first thing that I always share with everybody, but I think you know this, is I was stunned at how easy this was. As I drove up to Gilmer County for the first time, and I just wanted to go see one specific case, and that was the case against Derek Key, and that's the one that was a child molestation case, both out of Gilmer County and out of Cherokee County. The indictments were solid, the police work was solid. It was a very strong case that got dismissed after 44 delays over almost 10 years. Well, when I got up there, so first things first, I drive up into the parking lot, and I'm kind of going through my pre-battle routine, because I'm going into a courthouse and I'm going to demand to see documents. And I'm a citizen, and I'm Derek Somerville, and you're going to let me see these documents. Or I'm kind of getting myself ready. I get up there and there's a sheriff's deputies, and that's good because the law enforcement were going to be good. That's great. I go up to the counter and I'm ready for a fight. Like, to heck with it. Today's the day. And I go up there and I say, I would like to review all your criminal and civil cases. And she looked right at me. She goes, buzz, and buzzed me in, and that was it. That was it. So go do it. I was amazed. It was absolutely simple. And then I started copying. Now, what I thought was interesting, I think it's a bit of a passive effort by our government to prevent individuals from going too deep. They charged me 50 cents a copy. I made 1,700 copies in this process.
Wow.
And most of them are sitting here, by the way. So it's just, and the reason I bring these, and you can look at them later, is somewhat for effect. But there's something about the volume of it that reinforces the abuse, right? We get lost, and then we see the documents. You go, oh my gosh. And the other thing is, I just want your unbridled sympathy, because everyone was 50 cents a piece. And then I recorded and I analyzed the data, and I did this ad nauseum. Okay, ad nauseum I did this. Well, here's what I found, and you know this: 1,091 continuances by the speaker that spanned 279 cases, roughly distributed evenly across criminal and civil. One of the things that I discovered as part of this process is the media very understandably focused on criminal cases because they were egregious, they're emotional, they make you mad, with cases of child molestation, aggravated in some instances. But what I learned is that some of the civil cases were equally, well, not equally, but were very bad, because what was happening is people were being fleeced of their life savings because they were defendants in civil cases and they could never get to court. And they couldn't afford, each time that the court schedule was coming up and their attorney had to come, they were getting charged, and then Ralston would not show up. And it was a routine pattern that they would be sitting in the courtroom and the speaker just wouldn't show up. In one case, we have one that delayed 17 years. And the defendants, you may have read about this, purchased some property. Ralston's clients filed a lawsuit against them, put a lien on the property. For 17 years, they've not been able to get into court, so they can't access property that they're paying a mortgage on. Now, how is that not a government abuse? Because it's only made possible but for one reason, right? So anyways, as you can see, the largest concentration: Gilmer, Fannin, Union, Pickens, Cherokee, Dawson. I'd also point out, I redid this twice. So I wanted to make sure that when I went to the public with this, which was always my goal, was to just give it. It was my gift to Georgia. Say, here, you don't want to drive to Union County, trust me. So here it is. But I went through and I did it a couple different times because I knew this would be scrutinized to no end. Now, bear in mind that I went public with this in April, and nobody has yet come out and said there's anything, not a smidgen wrong with this data. Not one. On a year-by-year basis, this is kind of where you see the pattern in the abuse. He becomes speaker in 2010. So going into 2010, he has a 128% increase in his use of continuances. So immediately you have an argument that says, I think you have a problem doing both jobs. Let's say it's not a moral or ethical issue, it's just it's a logistical problem. Let's start in 2010 and just say, you know what? You clearly cannot do both, because you are now delaying cases 128% times more than you were, 128% more than you were before. But that's not what he did, because guess what? This is pretty lucrative. If you have the ability to delay a case without any scrutiny, you can take on as many clients as you want.
Yeah.
So you can, absolutely. And you can take as many. By the way, most of your clients are good with that because we're talking DUIs, we're talking any myriad of criminal activity, and then some of these civil cases. From 2010 to 2011, another increase, and then 2012, it's game on. It is game on. We're delaying everything. And the question at some point that should be going through your mind is, when did he go to court? And I've not yet answered that. I've not been able to answer that yet. I'd like to, but I did do something pretty close. Well, there's an interesting decline here in 2012, 13, and 14. And it's important because these patterns matter, right? It's one of the best things you can do as an investigator. The more data you have, you can start to develop patterns. When you have patterns, you can pursue an understanding of those patterns. And one of the things that was happening in 2012 is he was getting hammered over Amanda Mosher's case. And if you recall, Amanda Mosher was a young mother who she and her family of 4 were driving down the road, and a gentleman hit them from behind and killed her young daughter and killed her husband. So that case, it was about 2005. She had an attorney, or the defendant in that case who ultimately pled guilty to it, had an attorney that was having issues, so he brought on Ralston. Ralston delays that case for 5.5 years. Amanda Mosher held her baby daughter as she bled through her own hands and could not get in court for half a decade. When it finally goes to court, well, I'll come back to that. So 2012, she finally gets WSB to run the story. Not a lot of people realize this. This isn't new. In 2012, they're saying, hey, you know, this mother lost her daughter, lost her husband. The facts in this case are perfectly clear. There's no dispute about the facts in this case. It's no dispute whatsoever, and yet he delayed it year after year after year. In some cases, he's down at Rotary giving a speech instead of being in the court. And I should point out that these are not proactive letters. This is not him saying, oh, by the way, before you come to me court and tell me that you want me there, I'm going to let you know I'm busy next month. Each and every single one of these was him saying back to the court, I'm in receipt of your letter telling me you want me in court on Tuesday, and I'm not going to be there. So part of the narrative that he gave that was, well, you know, I have little control over the courts and I was proactively working. No, you were just telling him no. No, 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 no. It was like me back in high school trying to get a prom date. No. No. So through 2012, I'll back up. I mean, he's getting hit pretty aggressively, and he responded to it. So this is interesting to me too, because we're going to see this as we close out here in a few minutes, that he's responded to it yet again. If you need the media and public pressure and transparency and the truth to put you back on a moral path, maybe you should stay on it when you get back there, right? Maybe you should stay on it, but maybe you should do some soul searching, because this is not this is not a product of him going, oh, you know what, I need to stop doing this. This is a product of him being held accountable for it. And by the way, he was being challenged in 2014 in a primary, and they were nailing him for this, hitting him hard, right? A lot of power, a lot of powers. I will admit there's a purpose for the media. It's not always bad. It's not always bad. But you can see once that kind of relaxed, he wins this primary handily, he doesn't get challenged, and then the uptick starts again. Okay, so how crazy am I? This is a 10-year map, color-coded by county for every single day that he took off. So every single document that I had, I recorded the exact days that he told the court he couldn't be in there, right? Different than the date he submitted the letter, but the actual days. Well, what this allowed me to do was start to look for contradictions. Because out of all the 8 counties, I wanted to know, did he say one thing to you and then say another thing to you about the same date? I thought that was going to be powerful. Because I thought, well, what if you told this court that you couldn't be there because you were engaged in legislative duties and obligations, and yet you were in another court actually practicing law? Because to me now, that would be, well, you perjured yourself to one court, number one, and you've now stepped outside of the bounds of what that law was intended to do. And that's exactly what this map yielded. And I love this map, well, number one, because I know what kind of effort went into it, but it's an absolute source, single source of the truth. There's no denying this. It's every single document here. I also know no one's got the willpower to go redo it, but if they did, they're going to come up with the same.
2009 at the top and...
Correct.
Okay.
Working its way all the way down. And obviously smashed for effect, but I actually have a legible version of this and a searchable version. By the way, I took every single document and then I OCR scanned them so you could search them. Because here's what was working to his advantage, and I'm trying to stay on track because I know we have time limit here. Geography and time were his best friends, right? You can't build a pattern if you just go to Gilmer, or you just go to Fannin, or you just go to Cherokee. But if you could tie it all together, and if you could tie all the dates together, and you could put it in one spot where a blonde-headed Marine could understand it, then I assumed everybody could understand it. And quite frankly, when I took this public, I'm not certain that he understood the breadth of it. There's no way that he knew how many, where they were, where the contradictions were. So what that also allowed me to do is to say, well, how many days was he not in court? How many days did he say he couldn't be in court? And this number is actually, I've revised it up since this slide, but roughly 722 days out of session. So everybody kind of said, well, during the session, you got to make some allowance. Okay, I'll give you some allowance. Although I'm not so certain that a lawyer should get that benefit and a neurologist doesn't. If you're a CPA in the legislature, you don't get to say, well, I'm sorry, but all of my clients' returns are going to be delayed because I'm a legislator, and it's just, you can't, there's only one profession I do this for, right? But that's okay. So 722 days out of session, and what this did is it gave me a good sense of, well, how many days did you really have to practice law if you're going to practice law? Because the last I checked, I put priority around the things that I actually consider a priority. And in this case, he had 89 days in 2018. I actually think it's less than that now, but only 3 intact weeks. So there were only 3 5-day work weeks in all of 2018 that he afforded himself the ability to actually practice law. Well, if you go back to this, you go, the courts, one of his defenses was, well, the courts are overburdened, we don't have enough judges, it's very difficult to get on the calendar. Well, isn't that the argument to go to court when you can go to court? Because you know that if you don't, there's a good chance it's going to get delayed another year, or maybe worse. So you tell me, you look at this and you figure out how the heck do you work in a challenged court system where you have minimal criminal dockets and minimal time to get in there if you're doing this? How do you do that? And this, of course, right here, this is the actual sessions. These are the actual sessions. The bold are special sessions and actual sessions of the legislature. So by virtue of that alone, you're already blocking out a fourth of the year. How in the world can you look anybody in the eye and say that I'm going to be an effective steward of justice, and I'm going to do something that as Americans we hold pretty valuable? I'm going to move it forward with urgency, with due process. How do you do that if you say, except for my voluntary job that I could walk away from whenever I want is more important? And that's basically what this comes down to. This is more important. But Amanda Mosher's dead husband and dead daughter may argue otherwise. The victims of these 2 last aggravated child molestation cases, and they're good cases, and I'll talk to you about them if you want. They might argue otherwise. We might argue. We have to remember, once again, every single DUI that gets dismissed, well, that's the state versus. That's me versus. It's you versus. Imagine being a law enforcement officer in any of these jurisdictions.
Can you explain like 722 days out of session? That was like the other session for the sessions for 8 years.
These are low numbers for each of the years that he said I can't be in court. So in 2012, he basically told the court there's 110 days through a number of different letters that I can't be there. So basically, you look at it and you go, okay, there's roughly 250 working days out of the year. I'm going to be in session for what, 12 weeks, 13 weeks. And I'm going to take 110 days out of that. What am I left with? I'm left with nothing. Basically, no ability to prosecute, to move forward your caseload. And yet, during this time, and we don't have the time to go into today, he was taking on more cases than ever. He was building his caseload, but of course you would. It's like, if I'm a roofer, I just but I have legislative protection. You have to use me as a roofer, and I'll get to you when I get to you. Well, I'll just take everybody. Maybe I'll get to you in 10 years, which is the case with some of these.
How does he make money?
2 different ways. As a lawyer, well, I mean, that is where it's all about, right? So obviously as a lawyer, obviously as a legislator, and we don't, again, something we don't have time to go into, but all of this was cross-referenced against all of his campaign activity. So one of the ways that we nailed down most of the conflicts were looking at all the donations. So when you look at the amount of money that flows through the bank of David Ralston and then out to all the individual legislators, which is why he garners the support he gets, we're talking hundreds and hundreds and hundreds of thousands of dollars every year, right? It's a complex, we could come back and do that. It's a complex
You can't see where the law practice is making anything if he never goes to court.
You know, it's difficult to make money as a criminal defense attorney to begin with, but I agree with you. That's one of the big questions. But when you look at the clientele, how do you make much money defending a rank and file DUI repeat offender? They're not particularly affluent, yet they can afford the speaker. Another great question is, why is the Speaker of the House, would you even take a child molestation case? Why take it? There's some money involved, but that's where, unfortunately, I realize I'm now just a citizen. Because the next question would be, the next step would be to subpoena those records to get.
Why would he push it down to an associate to handle it? You know, say, you know, I'm not available.
Why is it great questions? Why wouldn't you? Yeah,
To adjudicate.
yeah, why not? Why wouldn't you? I don't think there's any motive. I think there's a couple things that come through here, and I've tried to reserve judgment, but I think I've seen in no shortage of criminal cases that oftentimes the criminal's lazy. They're not as sharp as you think. They're not as prudent as you think. In some cases, it's just convenient because nobody's questioning whatsoever. If we never looked at my son's report cards, I guarantee he'd never worked that hard at it. So no one's questioning it. It's going unchecked. And who's going to do this? I'm still questioning the sanity of myself for going through this. Well, let me push through a few of these. So there's a few themes that developed when we went through these letters, and we being mostly French for me, myself, and I. One was letters that were issued for sessions that had actually adjourned. So in these instances, and there's multiples, but I just want to show some, and I'll go quick here. In these cases, you have letters where he's certifying to the judge, hey, I'm going to be, number one, I see that I got a trial for the week of May 4th, but pursuant to the terms, as a member of General Assembly, I anticipate, which is curious, I anticipate being in the session at that time or within 3 weeks. Well, by February, you know when the session ends. I don't know why but this wasn't the case at all. This actually adjourned in 4/2, and the session ended in 4/24. So May 4th wasn't even near the ballpark. Well, why didn't anybody question it? Well, coincidentally, this one went to his former law clerk. Why didn't she look at it and say, sorry, you can't invoke leave for something that doesn't exist? But he did, and he never got checked. I have lots of these, by the way. Contradictions. So this is a good one. I actually tossed this in here last night because it was used in the bar rebuttal for Amanda Mosher, because she filed a bar complaint. They came back and said, hey, this is frivolous and it's a cabal and this is dumb. And then her attorney said, oh, really? And really delivered a response. And one of the things that we realized in that response was this contradiction. In this letter, Ralston says on July 31st, it's his signature, that he is going to be, that my legislative duties and obligations will require that I be away from the practice of law, that I be away from the practice of law and elsewhere on these dates. Dave Ralston. Boom. There it is. Facts. You have copies. In this letter, on August 19th, the week of August 19th, he says, I will not be practicing law. On August 19th, he was in the courtroom with Amanda Mosher settling the case. So how can you have it both ways? Is this not a perjurous statement? You just told a judge that you will not be practicing law. And yet on that day, the 19th, you're practicing law. Again, as I went through this effort, the effort started to validate the effort. That's why I kept going deeper and deeper, because he to this day has refused yet to just say, you know what, it got out of hand. We would have accepted that, by the way. We're very forgiving people. Unfortunately, we're intellectually apathetic on most issues, right? So we would have let it go. But these are real demonstrable examples that you say, well, you can't say that you're not practicing law on August 19th when you're literally practicing law on August 19th. And if you would have done this to a judge, well, do it, and then let us know how that turns out for you. Extended periods. You know, one of the things that this characterized as a legislative leave was to say, well, I've got court next week for 4 days, but I'm a legislator and I can't make those 4 days. In this letter, he just says, you know, to heck with it. This is what he says to the judge. Beginning on November 21st, I'm going to start prepping for the session, and I will be engaged in my legislative duty obligations through the final adjournment of the session. It's 131 days. He just told the court, 131 days, I'm not practicing law. Now think about this. If you got 60 to 70 cases, 131 days. So that meant that at least 6 weeks out of session, none whatsoever. Does anybody in the state realize he was doing this? Because everybody thinks it was to tell the court, well, I know you want me there on this date, but I can't be. In this case, he just said, nah, I want a continuance. There's no other lawyer in the state that could do this. You do have the ability, is anybody here an attorney?
Now you ask.
Okay, no, that's okay. Well, no, I mean, you correct me if you are, but this is accurate. If you want leave, you have it available to you to ask for leave, and the courts will grant it, and they most always do. But there are some provisions around how much leave you can receive in a contiguous period. And I think the law here is it's 30 days. I think it's 30 days. I could be wrong by a day or two. It certainly isn't 131 days. And this was never the intent of this law, by the way, which they, of course, have since amended. Some of the statements real quick, I'll try to push through this. Not all the continuances were requested by me. I think we now know that's just silly. Sure, there were continuances by others, but nothing compared to what he had. I literally could not go into a single one of his case files without the first, second, fifth document I saw being one of these legislative leave letters. And at first I thought, I'm going to find a few hundred of these things and no problem. But there were days when I went, especially in Gilmer, they're smart. They have all the computers up high, so they don't have them comfortable with a comfortable seat. They have to stand and work at them. And there were days where I walked into that courtroom just as it opened. I bellied up to that computer bar, and I did not stop printing documents. I didn't go to the restroom, and I didn't eat for 8 straight hours. Because it was far enough that I thought, you know what, you're a Marine, you can do this, don't stop, just go, 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 go. And each time, it's not like the old day, put a quarter in a video game. No, those 50-cent video games are expensive. How about as a lawyer, I have zero control over the court calendar? Well, that was ridiculous. He was the only one that had control over the court calendar. Judge after judge after judge said, hey, I want you in the court, and he just said no. I'll really try to push through this very quickly. Not one time in all my legal career, particularly during the periods of 2010, by the way, if you're investigating or you're interrogating, there's no reason to make that equivocating statement, but particularly during the time beginning in 2010, has a judge or a prosecutor in the circuits, which I practice, questioned my need for legislative leave. This is so patently untrue. The best example, and nobody knew about this, I found this in a rusty old, picture this if you will, old courthouse, small room, limited space, old kind of rusty metal cabinets, smells like folders, not air conditioned, peeling paint on the walls, and I'm done. I'm like, you know what, I'm going home. I'm tired, and I thought, you know what, I'm going to look at one more record. And I open up this drawer, and they're all wedged in so tight that you can't stick your hand in there without getting a paper cut. And I find that he was held in contempt and threatened with arrest in 2015. And I thought, well, that has not been reported yet. So what happened here is, and you can see it right here, that Attorney David Ralston were held in contempt for willful disobedience. This is October 2015, October 2015. And if you don't comply, I'm going to put you in jail. So the Speaker of our House is threatened with jail for failing to honor the court's wishes. And yet we're still told there's nothing here. There's nothing, and I'm a liar. And there it is. And of course, this is what they'll do because they're politicians. Well, he wasn't taking exception with my legislative leave. No, but he was taking exception with what you did with it. Because what he did with it is he ignored the opposing counsel's request as affirmed by the court for 2.5 years. Literally would not respond to requests for 2.5 years. And the opposing counsel, they had won the case. It was actually with Hertz Rent-A-Car. It was a big case. They had won the case. The judgment was already set. There was some discovery that was needed to be made. They were entitled, Ralston and his client were entitled to do it, and they just ignored it for 2.5 years. So when you read some of these letters, it's pretty important. Because here's what the people that were in the courthouse with David Ralston against him were saying. Learned attorneys, competent attorneys. This is an important opportunity for the court. This is the attorney that was motioning for contempt against Ralston. This is an important opportunity for the court to demonstrate that Mr. Ralston in particular and legislators in general may not take advantage of the broad freedom they are given by legislative leave by disregarding the duty to report it and to avoid using their privilege to effectively put parties in limbo for extended periods. Sound familiar? This is the theme. Here's another one. This is a separate attorney in a completely different matter. The movements can think of no reason for Mr. Ralston's involvement other than this case as a deliberate delay tactic. Mr. Ralston's involvement has greatly prejudiced and harmed the movements. This is a case that was that both parties have been represented for a couple of years. They were going to court in 3 weeks, or going to trial, done in 3 weeks, when one of the parties retained Ralston, and then Ralston immediately sent in a legislative leave letter and delayed it for another year or two. And what do? We're going to get together in court, and I know I'm going to lose. I get Ralston, and I say, see you later. And you can do nothing. Nothing. Here's another attorney. While the plaintiff respects the busy nature of Mr. Ralston's position, too busy to uphold our right to due process, plaintiff questions whether Mr. Ralston is honoring the spirit of the legislative leave law. Based on the history of his abuse and the privilege in this case, The court continues on it, the case will never go to trial. There's a theme here, right? It's not just me, it's not, here's yet another one. Plaintiff further shows a continued delay in this case is damage, it continues to damage by plaintiff. Please, Judge, clarify the proper use of this legislative leave law. There's a great story about this one that I don't have time to go down with what the judge did, but this judge acknowledged being a 25-year close friend of Ralston's and recused himself from the case when he was put under pressure to actually explain what legislative leave should and should not be used for. Yet another one. Despite the legislative, this is another judge or another attorney, legislative leave not being in session, Ralston has once again claimed legislative leave. While I appreciate everybody's being more than cordial, giving him plenty of deference, it appears that Mr. Ralston cannot balance his legislative duties and representation of his clients. And if it wasn't enough, you've got the prosecution themselves, the district attorneys, dismissing cases because, and they say, and I thought this was a powerful one, this is one of Ralston's cases, that the constitutional right to due process, especially that of the right to a speedy trial, requires that all cases by the state be brought in a timely fashion. So they are dismissing these cases, and we've got plenty of examples of that, for not because of poor police work, not because of anything other than a delay. Here you have a prosecutor that just says, I'm not constitutionally good with this. My job is to take that case and prosecute it, and I have to step away from it because the Constitution demands it. And that's the product of one man's behavior. And yet, we're told there's nothing here. That's what we're told. Well, on one day, March 4th, they dismissed 5 of his cases on one single day. 5 of them. Every single one of them said the same thing, due to the amount of time that has passed. And I don't need to go back to my mosaic picture of why that time is passing, but that's why. Every single one of it. 8 continuances on this particular DUI that lasted 4.5, 5 years. If you get a DUI in my county within 12 months, you will go to court, you will be arraigned, you will be sentenced, and you will pay your fine, whatever it is. You're either going to pay or you're going to go to jail. Period. No exception. If you murder somebody in my county, you'll get that. All those things will happen before that. Okay, so let's just real quickly wrap up here. Some of the cases that a lot of people heard, Derek Key, State versus Derek Key. This was a aggravated child molestation case, an enticing case, both out of Gilmer and both out of Cherokee County. What's unique about this case is the minor victim was willing, which the law, by the way, does not allow for. And this older individual wooed this young, kind of conflicted boy, convinced him to leave Gilmer County and go to his apartment in Cherokee County, where if you read the indictment, you would learn they did some pretty horrific stuff, right? This is a minor child. Minor child was sexually confused. Again, the law makes no provision for a child that is willing to participate with an adult in a sexual act. So what's unique about that is that there's no dispute, really. The minor was not disputing that the act took place. That case got delayed 44 times in the 2 counties. 44 times. And where's the sirens? Where's the red flags? And again, we're told nothing. Well, of course, it gets dropped. Cherokee County drops their half of the case back in October, I think, 2015. And just in May, the final disposition of the case up in Gilmer County, they drop it. This guy's done. He's good. He's walking free. He's free as his conscience will let him walk. And then we have another one. The other aggravated child molestation case, horrific case. I've talked to the victim in this one. I talked to the mother. And bottom line is that this case gets delayed for 6 years. They can't get to court. These are not people of means, by the way, making a living on $25,000, $27,000 a year. How do you go to battle when your daughter has been allegedly molested by somebody who's now retained the Speaker of the House and you can barely pay your bills? What do you do then? When you go to court and you go to court and you go to court and you don't get there. And effectively, this guy walked with a groping charge. You should read the indictment. It wasn't groping. And I love it when people say, oh, well, you can indict a ham sandwich. Well, if you're that ham sandwich, get David Ralston as your attorney. So these are all cases, by the way, that delayed for years and years and years. In a span of 8 weeks, he was able to clean them all up. Cheryl Shin, we're almost done. We're not down to the last couple slides. Jadon Carpenter was savagely beaten by an individual who has an extensive record and has been incarcerated for beating up women. When this story came out, Ralston had delayed this case, I think, 4.5, 5 years. Ralston just dismissed his claim. So for that 4.5, 5 years while she's trying to get to court, all that came out of it is her client got a free ride for 4.5, 5 years, and now he's got to go find a new attorney. He just walked away from that one. Okay, so I don't actually have a conclusion. I think this is the point where I think number one, it's not done. And the reason I don't have a conclusion is because it's not done.